Okay, the recording ended in part 2 of my evidence outline when I was going all in to the then existing mental, emotional, or physical condition exception to the rule against hearsay, and state of mind is another way of referring to that wordy exception. The definition is a statement of a declarant's then existing state of mind, such as motive, intent, or plan. Intent coming from Hillman. Or emotional, sensory, or physical conditions, such as mental, feeling, pain, or bodily health, but not including a statement of memory or belief to prove the fact remembered or believed, unless it relates to the validity or terms of the declarant's will. All right, so I'm just going to move on to injury reports. In other words, statements made for medical diagnosis or treatment. Statements of physicians for the purpose of medical diagnosis are exceptions to hearsay because self-interest breeds honesty, but are inadmissible if for the purpose to litigate, which is known as testimonial. The advisory committee notice is talking about expert testimony. So I'm going to skip on to recorded recollections. Exception to hearsay. This is exception to hearsay rule. If witness forgets her recorded recollections, these can be admissible under modern evidence law, used to prove the truth of matter asserted, only to allow witness to testify on present recollection. Procedurally, first show the opposing counsel and judge. In the advisory committee note, the law prefers recency for greater propriety. Federal law, California and New Jersey requires that witness not have faculties to testify without the recorded recollections evidence. There are some cases on this. No guidance on contemporaneousness. Multiple party involvement improves reliability. So for recorded recollections, again, reviewing the definition from the FRE is a record that is on the matter the witness once knew about but now cannot recall well enough to testify fully and accurately, was made or adopted by the witness when the matter was fresh in the witness's memory, and accurately reflects the witness's knowledge. If admitted, the record may be read into evidence but may be received as an exhibit only if offered by an adverse party. And I am hoping that we will soon see in the case law what is the difference. I have it here, and I'm going to look it up right now. So I highlighted it. I can't find it. It's not from the Hillman case. No. A lot suddenly on prior consistent statements. Where is the case about recorded recollection and recollection refreshed? Seriously. Oh, so there's a case where we just defined it. All right, well, instead of looking at here, we'll go backwards. Present recollection revival incorporate writing in the testimony of a witness, whereas past recollection recorded admits an independent evidence and allows writing to be read and reviewed by the jury. So, present recollection revival as opposed to past recollection recorded. Okay, so these are older terms. clearly, because the code today uses neither of them. I will mark it though. Present recollection revival is to incorporate, but past recollection recorded allows it to be reviewed by the jury, which would be entered as exhibit. Oh, harm is defined in 504 in that case. So that case is Fisher versus Swartz of 1955. What were we talking about? Present recollection revival. Past recollection reported. Again, this is not the terminology used in recorded recollection. So recorded recollection must just be the state of the law today. So what it is a record that is on a matter the witness once knew about and now cannot recall well enough to testify fully or accurately. It was made or adopted by the witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. If admitted, the record may be read into evidence, but may be received as an exhibit only if offered by the adverse party, and that's just it. Now, there's some minority in my jurisdiction intricacies, but that's clearly going to be the majority. So, I am skipping something. Oh yeah, I was talking about federal law, California and Jersey requires that the witnesses not have faculties to testify without recorded recollections evidence. So 1237 deviates. That's CEC 1237 deviates from FRE. And for that reason, I would say it makes sense to mark it. Or mark somewhere, maybe in the issues spotting template, that recorded recollection has a deviates from the FRE in California. And we'll give the CEC 1237 differs from FRE 803. All right, 5. Okay. So let's move on. About not very little. So business records in the Federal Rules of Evidence 803-6, they're talking about records of a regularly conducted activity rather than business records. But in my outline, litigants to prove commercial transactions through carefully maintained records went then by requiring testimony from all employees involved. Reliability and practical necessity voted in favor of this exception. Which the advisory committee notes that it relaxes the witnesses and participants needed to testify to the gathering and transmitting and recording of this information because it was overly burdensome. Qualifying businesses is defined as professions, occupation, or calling of any kind, and that is in the FRE as well. It says business, organization, occupation, calling. Doesn't have profession. And the report of the House Judicial Committee amendment satisfies the foundation with less burden and inconvenience of producing witnesses. Drop the definition of regularly conducted activity. 8038 deals with churches, hospitals, and schools, which I think is not true anymore. It's not. LOL. So, report of the conference committee, definition from model code rule, blah, 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 blah. Okay, 504 is written here. I'll look at 504 just on a tangent because I spent a lot of time trying to figure out like what is harm, what is like a reversible error, and harm is kind of a factor in determining if an evidential error is reversible. So I'm going to look up 504 to see if that's where it is. Seeing some I'm going to say rebuttable presumptions, but let me just see what's the actual terminology for that. As I page through, I'm looking at extrinsic policy exclusions. It's a nice way to refer to that. That one's about sex crimes. 501 is about privileges and attorney-client privilege work product. And 502, there is no 504. In my book. So that might be part of California. Find out quickly. Oh man. I do not like the way that this is codified. Cited. There's no 504 in the CEC. 504 no longer exists. Oh, I'm sorry. We're talking about model code rules? All right. Okay. Advisory committee notes to FRE 8036. This rule specifically includes medical diagnosis, prognosis, test results, opinions, acts, events, conditions as proper subjects of admissible entries, weather reports, accident report if regular, doctor's report if irregular, but not for litigating. If the motive is litigating, it's testimonial. And the example is all the railroad incident reports. Source of the info is something that limited business records. And that's not something I'm going to deliberate on. Absence of records, 8037. We read that, but in short, failure of a record to mention a matter which ordinarily would be mentioned is satisfactory evidence of its non-existence. So all this so far has to do with business records. And the best definition of business records is just in 801. I'm going to mark 801 with something, maybe just a pencil, or 803, I'm sorry. 803 is the best definition of records of regularly conducted activity. And absence of records, this is a better definition than I'm looking at right now. So I'm going to need some kind of way of marking it. I ran out of markers. Or it fell on the floor. But while I don't have a way of marking, I'll use these two and move on. Where you're saying that we like the definition of absence of records. And then after that comes public records. Now, public records has like a ton of like, I'm going to like it from my outline more just because there's a ton of factors and tests and stuff. So I might even like it from a case more than anything. With public records, it says it's narrower than business records. There's prerequisites for admissibility, which is the timeliness of the investigation, the special skill or experiences of the official, whether the hearing was held and level at which it was conducted, confrontation clause, possible motivation problems, and the formulation approach is probably a better verbalization of what I just said, which is agency records ordinarily admitted in case law history. So these are really the prerequisites in my view. Agencies are and have been, let's just say, and have been sustained on appeal and evaluate the report on the factors above. So these prerequisites are actually factors, and the formulation approach is actually prerequisites. So I'm going to say factors, and then I'm going to say prerequisites in the right place, I think. And I'm going to mark this up because this is a better definition for public records than I had before. Former testimony. Just skipping along to former testimony of declarant presently unavailable is covered in 804 ANB1, as well as CEC 1290 through 92. It includes depots, earlier hearings in the same case, and i.e. on appeal, criminal and civil distinctions, motive of second proceeding the same, may be barred by confrontation clause nonetheless, and Crawford and Davis are examples of them. I think my favorite example is like probably nowhere near this section of the book, but there was a criminal case where the defendant later brought police brutality, and earlier statements were able to be used by, surprisingly, the defendant's sister, because the defendant died and there was privity according to some crazy rule that I'll probably not have to know again. So let us now keep on moving on. Preference for party to testify but unavailable. Oath, cross-exam, demeanor, motive factor, mutuality, now discredited, substitution of successors by narrowly construed privity can be admissible. So yeah, so that is the case, the privity that I was just talking about. And then there's a treatise on public records. And then there's, which is former testimony is not accepted by public records, which treats it as testimonial hearsay, and then allows former testimony without foundation. So I don't know, but it had to do with public records. Former testimony treatise defines person in privity as a person with whom the present party received a right, title, interest, obligation at issue. No definition to predecessor and interest, but similar to person in privity, which I just said. And then different approaches applied exclude for absence of appropriate motive. Substantially identical issues existed in both actions and similar motive and meaningful opportunity to cross-examine. So there's your three factors of former testimony. Does it require that the person's not available? Let's see if it says so in the issue spotting checklist. Former testimony, unavailability exceptions. So it also requires unavailability. So I'm just going to put that as a factor here. All right, now, going on, you got Boland, you got Kirk, and on the next page is Volan Golden versus City of Chicago is the case that I was talking about with the privity, and it goes over like all the factors I just said, I'm assuming, in the similar motive, or what is similar motive, if you needed a definition of similar motive. For purpose of exception to hearsay rule for admission of former testimony of an unavailable declarant when the declarant or testimony is offered against a party whose predecessor and interest had similar motive to develop it is, so we got a lot there. It's a former testimony, unavailable declarant, offered against a party, predecessor and interest had similar motive to develop it, is inherently a factual inquiry depending on part of the similarity of the underlying issues and on the context. Moreover, like the inquiries involving the admission of evidence, the similar motive inquiry appropriately reflects narrow concerns of assuring the reliability of the evidence submitted at trial. Blah, 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 blah. Public policy. Okay. The similar motive to develop it, the type of proceeding in which the testimony is given, the trial strategy, the potential penalties or financial stakes, and the number of issues of parties. Dying declarations. Dying declarations. Sometimes evidence entered by business record for reliability, practical necessity. McCormick on evidence says there's arbitrary limits and special likelihood of truthfulness of deathbed statements. It was established in the 1700s and exceptions apply. The advisory committee note is now about expert opinions again, I think, and firsthand knowledge, and only criminal homicide, not civil. Since overcome, whatever I just said, and circumstantial limit banded, not to attenuated. That's what the advisory committee note said. And the report of House Judiciary Committee, lower limit based on attending circumstances, expend to greater criminal, less than civil with less than 1 year prison sentence, and exceptional need for evidence criteria for prosecution use. So I don't have any idea what any of those treatises are supposed to really mean, but here's what I do know. FRE 804 is basically when a declarant is unavailable and using hearsay. Apparently I don't have it marked in the book. No, I do. So the best definition of dying declaration is going to be from FRE 804B2. Yep. And CEC 1242, which is different, I hear. And in FRE 804B2, statement under belief of imminent death is in a prosecution for homicide or in a civil case, a statement that the declarant, while believing the declarant's death to be imminent, made about its cause or circumstances. Whereas in the California Code, it's 1242. I'm really going to need some markers because I want to mark this because this is just too easy to be tacit on for a person who's unprepared. 42, dying declaration. Evidence of a statement made by a dying person respecting the cause and circumstances of his death is not made inadmissible by the hearsay rule if the statement was made upon his personal knowledge and under a sense of immediately impending death. I think the difference here is that he doesn't have to die, I guess, because I otherwise see no difference. Here's what I'm going to do. I'm going to mark it with a note card. All right. So I'm going to pass through a case or two. And declarations against interest rule includes statements subjecting the declarant to criminal liability and statements tending to make him the object of hatred, ridicule, or disgrace. What's wrong with that? Declarations of interest is right here. What else does it require? Unavailability and corroborating testimony. So I'm going to just, rather than mark it with an imaginary marker, I'm going to staple the note card to this page. And recall that it's in FRE 804. And the other thing that I wanted to mark was pertaining, here's co-conspirators, and here's qualifying business records, but there's nothing really said there, so I'm going to mark 803 exception. No, we're not. All of these note cards are probably not important, so I'm going to hide them. Unless needed for some other reason. Not hearsay is a prior inconsistent statement. I'm going to hold on to that. What was I looking for? I was looking for what I thought was a really good definition was former testimony. Well, I like this former testimony. Where does that come from again? Here's agent employee admissions. Here's the 409, 411, multiple hearsay, public records, prior identification. FRE 407 for blah, blah, blah. I feel like this all has to do with remedial measures. Okay. Got a lot more to go through. Forfeiture by wrongdoing. That's an unavailable witness. Hearsay can be admitted if there was wrongdoing. Here's dying declaration. I'm going to use this to mark the California page. That's just a blank note card. There you go. The real thing. I don't know what definition I liked, but I really like this former testimony. Where did former testimony? Oh, here it is. It's from 804. It's an 804 exception. So there's the residual exception. Present sense impression. Admissions and multiple hearsay, entrapment, void defense privilege, work in progress, privileges. 408 had to do with 409 had to do with offering medical payments. 701 has to do about either lay or expert opinions. This one's lay. 704 is lay. 701 is lay. Impeachment rehabilitation. Obstruing. Then existing mental. Yada, yada, yada. Please. What are those called again? Okay, so I don't have anything on former testimony. I like it, and I say I make a new note card. Hey, wait, there's another set of note cards here that might be nice. Might have something about it. What's up there, though? 404, adoptive emissions. What's this? Judge determines if expert is qualified. So this is probably in the 700s. Allows duplicates to be introduced in the same manner as originals. That's FRE 1003. 1004 is original is not required. Other evidence of the contents of the writing and other evidence of the contents of the writing admissible if all originals are lost or have been destroyed unless the proponent lost or destroyed them in bad faith. To prove the contents of a writing, recording, or photograph, the original writing, recording, or photograph is required. That's 1002. Writings and recordings defined in 1001. Tangible items which are not themselves contended to have played any part in history of the case, but which are instead, and that's demonstrative evidence, authentication, where the testimony is assailed as fabrication. Okay, this is fabrication. Evidence of truthful character inadmissible only after evidence of witness, okay, is attacked. That has to do with bootstrapping again. Isn't that right? Okay, and then what's this? Accused may always bring forth evidence of a pertinent character trait that his reputation for truth is pertinent in the instant case. That's a 4B. Someone makes I think it opens the door, though, to add on. Someone makes an accusation and the accused does not object. That's an adoptive omission. Yes. And I don't have a card for former testimony. So I'm going to make one and staple it to my outline because I liked that definition. At least it's more of a formulation that's saying that got to have an unavailable witness and they had to have identical issues and motive, and at the time of the former testimony must have been subject to cross-examination. This is page 30. I feel like there was something else that I really liked. Public records. Public records, I already marked that. Okay, so maybe that was my issue, is that I had to mark public records and absence of records. I like that definition too. And so I marked dying declarations. I don't like it so much, so I'm not marking it. And then we're skipping a bunch of cases. And then I got to declarations against interest. And rule includes statements subjecting the declarant to criminal liability and statements tending to make him the object of hatred, ridicule, or disgrace. I like that. He has to be unavailable according to this note card. And it requires corroboration. So unavailable requires corroborating. Yes, both of those are written here. We finally have something good coming out of my outline. Then there's two cases. Then there's forfeiture by wrongdoing. Common law exception for when a party file defies common law witnesses unavailability. I want to say willfully. I don't know if that's what I was trying to say, but when a party willfully defies witnesses' availability. That's just stuttering. And then this happened in Giles versus California. And so move on to the next page, which is the residual exception. And what I like to say is I have note cards for these, so I'm just going to mark it by attaching my note card. Residual exception in my note card is reliable, highly probative, but not admissible under any other exceptions. Rule, allow court and case by case basis to introduce out-of-court statements that seem reliable and highly probative and aren't covered by other exceptions. Possibly expanding, supplementing traditional hearsay exceptions. Got a couple of treatises here about how it fits in the code altogether and strikes a balance between hearsay flexibility and certainty. And many people like the case-by-case approach. People probably don't also, but they like the flexibility, and FRE is not a straitjacket now. Hearsay and due process. Due process and confrontation clause are constitutional restrictions on hearsay. Exercise right to confront, cross-examine, and call witness on one's own behalf. So, forfeiture by wrongdoing we just discussed, right? Forfeiture by wrongdoing. Yes. And then we talked about the residual exception, and now we're talking about the confrontation clause, which I marked previously. And where it is that I marked it, a very short little blurb, I will add what I'm seeing here. And what I'm now seeing here is it saying confront, right to confront, plus cross-examine, plus call witnesses on one's own behalf. To the extent that's important, I just wrote it down. Nonetheless. And we got to the residual exception. Is that kind of where I am? Okay. This is the confrontation clause. Very nice. But I marked it elsewhere and just added that where it was. So we move on to character evidence. So as far as hearsay exceptions go, I am just stapling all of this together. They're all related, and it's all marked up and crazy. And we're moving on to chapter 4 about character. The basic rule of hearsay exceptions, all covered in FRE 404A, character evidence limitation prohibiting an inference that a person acted in conformance with his character on a particular occasion because that evidence is unduly prejudicial. And I have no cards for that, but I'm going to use to mark that. I'm also going to attach all of these to that section because they are all the same. They all come from that section. Authorized omissions and existing, with the testimonial, presence and suppression. All that's related to that, so I'm going to just click it in here and then maybe I'll staple it later. We're at 40 minutes in this recording, and I'm looking for 404A about character. Now I see habit right here, so it might be right below it. Yes, it is. But I'll keep out habit because that's going to be special for some reason. Its moment is coming up. Character. So maybe I'll hold out this last page actually from hearsay exceptions because it enters character. Now, what does it say on this postcard? Generalized description of one's disposition in respect to a general trait: honesty, integrity, temperance, peacefulness. I hate that definition. So, I think I like this definition much better that's in the outline. This is much better. Okay. So what does it say on the next page? Evidence of a character trait is barred only if it is offered to prove conduct in conformity with trait. Now, for character of criminal defendant, if invoked by defendants by opening the door, for a character of victim or alleged victim of criminal offense, and for the character of a witness. Those are the 3 exceptions to the character rule, but there's also for impeachment and for rehabilitation. So these exceptions to character evidence limitation are 5-fold. Advisory Committee Note to 404A. Reward a good man, punish a bad man because of character despite evidence. Character and issue, character itself, element of crime or defense claim. Example, chastity is an element of crime of seduction, resulting from great prejudice, less probative in value. Circumstantial, suggesting an inference that person acted on an occasion in question consistently with character is another way to say the same thing. Which I don't disagree with that wording. Resulting from great prejudice, less probative in value. Rejected in 3 exceptions. Good character entered by defendant to rebut allegation. Character of victim is self-defense if self-defense is claimed. For example, consent in rape or first aggressor in violent crime, and character of witness if bearing on credibility. McCormick on evidence just kind of says something's not fair. And then methods of proving character typically applies to certain kinds of evidence when one of 3 exceptions involving testimony about a person's reputation or witness's own opinion of a person's character. An example, identification of how a person behaved in similar situation is excluded. The Advisory Committee Note to 405, evidence of specific instances of conduct most probative, convincing, but time-consuming, confusing, source of surprise, and prejudice constrained to use when character is at issue. Advisory Committee Note to 803-21, traditional acceptance of reputational evidence to prove character was limited by 404 relevancy and 608 character of witness. I laugh because, I never read up until today 803-21, which does talk about reputation. But what it's saying here is that 404 relevancy, okay, that's that as part of the analysis. But 608 character of witness, wondering if that's something this book is saying historically was how this was handled, or if it still is. And whoa, I just read writing used to refresh a witness's memory. This rule gives an adverse party certain options when a witness uses writing to refresh memory while testifying or before testifying if the court decides that justice requires the party to have those options. Adverse parties options: deleting unrelated matter, failure to produce or deliver the writing, witness's prior statement. 613, showing or disclosing the statement during examination, extrinsic evidence of prior inconsistent statements. So this stuff is kind of important for practicing. And I'm going to mark it because it might also help me answer questions. I was going towards 608. That's where I was turning to. 609 is impeachment. 608 is witnesses' character for truthfulness or untruthfulness. This comes up in my essays to date. A witness's credibility may be attacked or supported by testimony about a witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. But evidence of truthful character is admissible only after the witness's character for truthfulness has been attacked. Specific instances of conduct. Except for criminal conviction under Rule 609, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support a witness's character for truthfulness, but the court may, on cross-examination, allow them to be inquired into if they are probative of the character for truthfulness or untruthfulness of a character or another witness whose character of the witness being cross-examination has testified about, and by testifying on another matter, a witness does not waive any privilege against self-incrimination for testimony that relates only to the witness's character for truthfulness. So this doesn't really talk to me about like the exception for self-defense and when a witness is unavailable. And that's okay. So we were in methods of proving character. And we're done with that now. Because 608 is here about how to do it. And then there's some cases. Other uses of specific conduct, FRE 404. Conduct on other specific occasions cannot be character evidence, but may support state of mind. Permissible purposes. And this is where we get into the mimic, mnemonic that we were just talking about. Motive, opportunity, plan, modus operandi, identity, intent. Motive, identity, modus operandi, intent, plan. What's the C stand for? I don't remember. It's not really here. It's something. So this talks about all the cases in which the permissible purposes were used, not for propensity, but for a state of mind, etc., which is formulated by the intent, their motive, their, in terms of state of mind refers to a part of a state of mind is your intent. Your motive is part of your state of mind. Opportunity is probably relevant for determining your intent or motive. Plan. And it's not like necessarily the plan that you wrote down, but the fact that maybe the mind's intent or the mind's putting a plan together, planning, the active planning, and modus operandi, identity, whatever. None of these are definitions, they're just cases that explain those things. These things are all put together in 404. So I need to find 404. And there's some more cases. 404B provides that such evidence may not be used to prove a person's bad character or his propensities to commit crimes in conformity with that character, but may be used for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, or absence of mistake or accident. So there's some new ones. Knowledge or absence of mistake. So let's call this 404B. Knowledge, absence of mistake or accident. And I find it hard to believe that 404B could read any better than that. Itself. Oh, there's 609. There's 609. have a note card for 609. I'm going to take this sticky and I'm going to move it to 608. And I don't have to, but that's fine. We're going to move to 404 to read what that really actually says. So it's right after the relevance test. Here's character evidence, and there's my other stickies. Good. Prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. Exceptions for a defendant or victim in a criminal case. Here's your exceptions. The following exceptions apply in a criminal case. A defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it, and that's opening the door. Now, B, subject to the limitations of 412, a defendant may offer evidence if an alleged victim's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it and offer evidence of the defendant's same trait. And C, under the exceptions, is in a homicide case, the prosecutor may offer evidence of the alleged victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. And homicide being obviously that witness is not available to testify. And then the exceptions for a witness. Evidence of a witness's character may be admitted under Rule 607, 608, and 609. 7, 8, or 9. I just kind of breezed beyond them. One of them was character for truthfulness. That was 608. 609 was impeachment. What's 607? 607 is who may impeach a witness. Any party, including the party that called the witness, may attack the witness's credibility. Crimes, wrongs, or other acts. I think this is called extrinsic evidence. Sometimes it's called prior acts. Sometimes it's called prior and charged acts. Just read to make sure. Prohibited uses. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. Permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, and absence of mistake or lack of accident. So that's where the B2 is actually where fishing for what I just found. Notice in a criminal case. In a criminal case, a prosecutor must provide reasonable notice of any such evidence the prosecutor intends to offer at trial so that the defendant has fair opportunity to meet it and articulate in the notice and permitted purpose for which the prosecutor intends to offer the evidence and the reasoning it supports the purpose, and do so in writing before trial or in any form during trial if the court for good cause excuses lack of pretrial notice. So this is your 404 character exceptions and extrinsic evidence allowed, and I'm going to mark it as such. I'll give it mimic. Getting a little bit tired out of this recording. Mark it here too. I don't even know if this is an open test. So I'm going to stop on page 40, which is a little less than halfway done. reading my outline. And actually, I'm not. I'm going to finish this chapter. Because the next chapter is impeachment and rehabilitation. And we don't have much to go. We really should get sexual assault and child molestation, which is talking about the rape shield statutes, which should be in 412 and CEC 1103, which I'm sure is different. So let's just go to 412. Methods of proving character is 405. Habit is 406. Evidence of a person's habit or an organization's routine practice may be admitted to prove that on a particular occasion the person and the organization act in accordance with the habit or routine practice. The court may admit this evidence regardless of whether it is corroborated or whether there is an eyewitness. 407, subsequent remedial measures. Oh, here's 412. A note card for it is really long. And I think it has all to do with the alleged victim of sexual assault. And I could just read that whole thing. And I very well might. Four, 7. It's right here. I was going to 412, hoping that 412 says it better than my note card does. And I can't confirm that until I page there. 409. It's 407, 408, 409, 411, 410, 412. Okay, 411. All right, and now we're at 412, which is the note card that I just pulled. And let's see how, actually, it probably is directly from the code now that I think about it, but easier to read out of the book. So for sex offense cases, the victim's sexual behavior or predisposition, prohibited uses, the following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. 1, evidence offered to prove that a victim engaged in other sexual behavior or evidence offered to prove victim's sexual predisposition. Exceptions. Criminal cases. The court may admit the following evidence in a criminal case, evidence of the specific instances of victim sexual behavior, if offered to prove that someone other than the defendant was the source of semen, injury, or other physical evidence. Evidence of specific instances of a victim's sexual behavior with respect to the person accused of the sexual misconduct, if offered by the defendant to prove consent, or if offered by the prosecutor, and evidence whose exclusion would violate the defendant's constitutional rights. Civil cases. In a civil case, the court may admit evidence offered to prove a victim's sexual behavior or sexual predisposition if its probative value substantially outweighs the danger and harm to any victim and of any unfair prejudice to any party. The court may admit evidence of a victim's reputation only if the victim has placed it in controversy. Procedure to determine admissibility. Motion. If a party intends to offer evidence under Rule 412B, the party must file a motion that specifically describes the evidence and states the purpose for which it is to be offered. Do so at least 14 days before trial unless the court for good cause sets different time. Serve the motion on all parties and notify the victim or, when appropriate, the victim's guardian or representative. Hearing. Before admitting evidence under the rule, the court must conduct an in-camera hearing and give the victim and parties a right to attend and be heard. Unless the court orders otherwise in motion, related materials and the record of the hearing must remain sealed. Definition of victim. In this rule, victim includes an alleged victim. There's a lot of historical basis for why this was set up, and there's actually a lot of people that are against it because they think it's already included in like 403 or something. There's some nuances too. So historically it was highly probative, admitted, so this is the purpose of it, is admitted even when no issue of consent, evidence overvalued, misused, distracting to the jury. In the advisory committee notes, it applies to civil and criminal allegations of sexual misconduct, kidnap, and sometimes harassment based on balancing tests. Shift burden from the defendant to object and to proponent to demonstrate admitted admissibility. Rates threshold for admission. Crime to victim on scale alongside prejudice to defendant. Bars mode of dress, speech, or lifestyle that has sexual connotation from fact finder. It includes behavior of mind. Bars substantive evidence and impeachment evidence on dress, etc., and except not applicable to third-party witness. So here's some cases, and character of defendants is the last page we're going to get to before reaching impeachment. So regarding prior misconduct and sexual assault and child molestation from FRE 413 through 15, and also considering CEC 1108 to 1109. This is about the person who has been convicted more than once in sexual assault cases. And 413 is still in my book, and straight through to 415. So there's a bunch of remarks about, again, this is duplicative of what's already in 404 and 405. So there were a lot of parties that were against including this. And I'm going to read it from the code. Rather than the back and forth. So, similar crimes and sexual assault cases from Rule 413, A, permitted uses. In a criminal case in which a defendant is accused of a sexual assault, the court may admit evidence that the defendant committed any other sexual assault. The evidence may be considered on any matter to which it is relevant. Disclosure to the defendant. If the prosecutor intends to offer this evidence, the prosecutor must disclose it to the defendant, including witnesses' statements or a summary of the expected testimony. So this is like extrinsic evidence that can actually come in because it is of a sexual nature and probative. And so these are the rules around it. It requires notice, 15 days, okay? Effect on other rules. The rule does not limit the admission or consideration of evidence under any other rule. Definition of sexual assault. In this rule and Rule 415, sexual assault means a crime under federal law or under state law as state defined involving any conduct prohibited by the United States Code and contact without consent between any part of the defendant's body or an object or any other person's genitals or anus, and contact without consent between the defendant, said parts, and any part of another person's body. Derive sexual pleasure or gratification from inflicting death, bodily injury, or physical pain on another person, or an attempt to conspiracy to engage in conduct described in those paragraphs. It doesn't say anything about convictions. So it just says a defendant is accused. In a case when the defendant is accused of it, the court may admit evidence that the defendant committed any other. So what is the definition of committed? Because if you're charged and you weren't convicted, I think that should matter. Similar crimes in child molestation cases. Rule 414, permitted uses. In a criminal case in which a defendant is accused of child molestation, the court may admit evidence that the defendant committed any other child molestation. The evidence may be considered in any manner to which it is relevant. Disclosure to the defendant, again, 15 days. If the prosecutor intends to offer this evidence, the prosecutor may disclose it to the defendant, including witnesses' statements or a summary of the expected testimony. The prosecutor must do so at least 15 days before trial or at a later time if the court allows for good cause. And effect on other rules. The rule does not limit the admission or the consideration of the evidence under any rule. Definition of child and child molestation. In this rule, in Rule 415, just look at this real quick. Come on, evidence. When does this thing start? Okay, it starts at 9:15. Okay. If you say so. All right. So, what was I saying? A definition of child and child molestation. Who cares? Rule 415, similar acts. I need to know. Child means a person below the age of 14, and child molestation means a crime under federal law or under state law, as state has defined in the United States Code, involving any conduct prohibited by Title 18 of the United States Code, Chapter 109A, committed with a child. Any conduct prohibited by that title, Chapter 110, contact between any part of the defendant's body or an object or a child's parts, contact between the defendant's parts and any part of a child's body, deriving sexual pleasure or gratification from inflicting death, bodily injury, or physical pain on a child, or an attempt or conspiracy to engage in the conduct described in those earlier paragraphs. And for Rule 415, similar acts in civil cases involving sexual assault or child molestation, permitted uses. In a civil case involving a claim for relief based on parties' alleged sexual assault or child molestation, the court may admit evidence that the party committed any other sexual assault or child molestation. The evidence may be considered as provided in Rules 413 and 414. Disclosure to the defendant. If a party intends to offer this evidence, the party must disclose it to the party against whom it will be offered, including witnesses' statements or a summary of the expected testimony. The party must do so at least 15 days before trial or at a later time that the court allows for good cause. Effect on other rules. This rule does not limit the admission or consideration of evidence under any other rule. Okay, so here's at the end of this comes privileges. And I got all these note cards about privileges. So I'm just going to stick them there. And, and to end this recording, I'm going to take a break.